Ladies and gentlemen, our speaker is here. Our next keynote speaker, joining us via Skype, is Professor Alan Dershowitz. Professor Dershowitz clearly needs no introduction, but I will give him one anyway. Professor Dershowitz is an American lawyer, prolific author, political activist, and prominent academic who specializes in constitutional and criminal law. He was a professor at Harvard Law School between 1967 and 2013, holding the prestigious Felix Frankfurter Professorship for 20 years. He was, at the time of his appointment, the youngest full professor in the history of the law school. He is the author of numerous books and articles, including The Case for Israel. Professor Dershowitz is a recipient of the William O. Douglas First Amendment Award from the Anti-Defamation League, the Soviet Jury Freedom Award, and the Menachem Begin Award of Honor. He holds a JD from Yale University School of Law, where he was editor-in-chief of the Yale Law Review. And he currently has a book coming out this August called Defending Israel, the Story of My Relationship with My Most Challenging Client. I, for one, look forward to reading that book. Please join me in welcoming Professor Alan Dershowitz.
Thank you. Thank you so much. It's always a pleasure for me to speak at conferences sponsored by Shurat HaDin. It's a wonderful, wonderful organization. It has become one of the most important weapons in the war of public relationship and the war regarding Israel and its enemies. And this conference, which is called Law and War, of course, for somebody like me from Brooklyn, law and war actually rhyme. For those of you who are not, it's law and war, but for me, it's a rhyme. And you understand as an organization better than most how the laws of war have become a double-edged sword. They can be used to protect, they can be used to defend, and they can be used aggressively, as they have been for many years now, against the nation state of the Jewish people. A little history to begin. Obviously, many of you know that the law of warfare really begins in the Torah, in the books of Deuteronomy and Leviticus. There are prescriptions for how wars can be fought and should be fought. Jewish law has a long tradition of describing humanitarian constraints on war. And but modern law of war really emerged following the Second World War, particularly with the Nuremberg trial. My mentor and friend Telford Ted, who was also active with me in the Soviet Jewry movement in the 1970s, was the United States chief prosecutor at Nuremberg and helped with other people like Ben Ferenc, who's still alive and who is the subject of a new film called Prosecuting Evil, how the law of war emerged at the end of the Second World War. Several years ago, I wrote a book called Rights from Wrongs, in which I argued that rights generally come from a recognition of wrongs, and that the Second World War, with its immense wrongs on both sides, but particularly, obviously, on the side of the Nazis, generated need for reconsideration of the law of war, and saw tremendous progress made in terms of treaties, in terms of academic work, and really the law of war became mature in the years following the Second World War. The Nobel Prize was won by Stahl, who helped formulate the United Nations Declaration of Human Rights. And for several years, probably a decade or two even, after the end of the Second World War, we saw the laws regulating war applied objectively and neutrally to all countries in an effort to really achieve the rule of law governing the actions, military actions. That changed in the 1970s, There were many reasons for that. In the late 1960s, 1970s, I taught the first course at Harvard Law School on the law of war regulating the Vietnam conflict. You all remember, if you're old enough to recall, that the Vietnam War created a terrific conflict. Again, my friend Telford Taylor wrote a book called Nuremberg in Vietnam, in which he tried to apply the Nuremberg principles to the Vietnam War. But then following the Yom Kippur War, people like Daniel Berrigan and Noam Chomsky and others tried to weaponize the laws of war against Israel. When the Soviet Union broke diplomatic relations in 1967, the pressure after the 1973, hard left academics began to distort the laws of war to turn weapons against the nation state of the Jewish people. And there were really three components of the laws of war that I would like to briefly discuss each of them today and how they apply to the current conflict world, particularly the conflicts between Israel, the Palestinians, and the Arab state. The three concepts I want to are jus ad bellum, is the laws regulating when it's appropriate to wage a war, jus ad in bello, when it's appropriate to take certain actions within a war once the war is being fought, and jus post bellum, what the rules are following a war, particularly a war in which a nation has been victorious. Israel was in the 1967 and 1973 wars. So let's start with jus ad bellum, when it's appropriate to wage a war. And academics have made a distinction, and it's a distinction which sometimes holds and a distinction which sometimes becomes a matter of degree, but a distinction between preventive war and preemptive war. Now, we all understand what preemptive war means. Israel's attack on the Egyptian Air Force and the Syrian Air Force in June of 1967 was the paradigm of a preemptive war, and that's taught in law schools and political science departments all over the world. Israel had reason to believe that Egypt was on the verge of attack, and it had the right under laws of war to preempt that attack by destroying the Air Force that was poised to try to attack Israeli civilian targets. Israelis now claim that Egypt was only bluffing in 1907, that they really weren't planning to. No one will ever know the answer to that question, and it's irrelevant to the law of war because the law of war requires that the attacked nation reasonably believe, and that be objective evidence to reasonably believe that they were at risk of being attacked. And obviously the decision by Nasser to close the Straits of Tiran, to throw out the UN observers, and to move troops into the Sinai Desert in close proximity to the border to Israel constituted a sufficient act of war to justify Israel taking preemptive action. And the world recognized that. And Israel was not condemned. That the United Nations, by academics, a few extremists, tried to make the argument that Israel could have waited longer, but Israel was justified. And that helped to establish precedent for preemptive attack. Now we come to preventive war. That's much more difficult concept, and a concept that is very important right now in the context of Iran and its ability to spin centrifuges and perhaps create a nuclear arsenal, which it has sworn in the agreement that it is a signatory to, that the United States recently left. But it was agreed that it would never, under any circumstances, seek to develop or acquire nuclear weapons. Were Israel or the United States or anyone else to decide that the risks of a nuclear-armed Iran were too great to tolerate, and they decided to attack the nuclear reactors, Israel attacked nuclear reactors in Iraq and in Syria, those actions would be deemed preventive war or preventive military actions. And the law on preventive military actions is very unclear. Many academics believe it's not proper. The position of the United Nations is that it might be proper, but only with the Security Council approval. Of course, that fails to recognize the reality that the Security Council, with vetoes by Russia and China, would never allow Israel or the United States to take legitimate, reasonable preventive actions against an Iranian nuclear reactor, did not justify the attack on the Iraq reactor. In fact, the United Nations, with the vote of the United States, unanimously condemned Israel for that attack. Of course, the United States then 10 years later thanked Israel for the attack. When Iraqi troops moved into Kuwait, they would still be there if they had the nuclear weapons that Israel destroyed. The world did not condemn Israel when it attacked the North Korean built nuclear reactor in Syria, because Syria didn't want to acknowledge, North Korea didn't want to acknowledge it was even building a reactor. And that was a pure act of preventive military action taken by Prime Minister Ehud Olmert. And although the United States opposed it, President Bush opposed it, President Bush then congratulated Prime Minister Olmert for taking action, which prevented many, many more deaths. Imagine what the situation would be today if Assad had nuclear weapons instead of the barrel bombs he is throwing at his own civilians and at people who oppose him. So there is no doubt that preventive war can sometimes achieve just results. Let me give you an example from history. And I'll use this example to explain the difficulty of trying to justify preventive war. If Winston Churchill had been the Prime Minister of England in 1935 or 1936, and he saw that Germany, in violation of the Versailles Treaty, was building up its weaponry and its armaments, and soon might become the most powerful army in all of Europe, again in violation of the Versailles Treaty. One can easily imagine Winston Churchill and the Prime Minister of France at the time saying, look, we really have to stop this monster Hitler. We've read his book, Mein Kampf. We know what he intends to do. He intends to capture Europe. He intends to genocide. We have to engage in a purely preventive war. And the critics would say, well, but you might end up killing 10,000, maybe 100,000 people. And had Britain and France attacked Germany and destroyed its nascent military buildup in 1935, it would have been condemned by the world. Killing 100,000 people in order to stop a tin horn dictator who wrote a book called Mein Kampf, he never would have carried it out. We have to remember that history is blind as to the future. History never can tell us what would have happened. History is not continuous. So history would not have known, and the rules of war would not have known that a preventive attack on Germany in 1935 would have saved 50 million lives, would have prevented the Holocaust, would have prevented the capture of all of Europe, would have prevented so much heartache and so much destruction. And yes, it would have cost 10,000 or 100,000 lives, but any sense of proportionality would say that that use of military force was justified. But because nobody would have known what would have happened, now we know because there was no preventive attack. But we wouldn't have known had there been a preventive attack. Churchill would have been called a warmonger. He would have been attacked. He would have been called a war criminal. Had we had an international criminal court, he might have been brought to trial in front of the International Criminal Court. That's the danger of completely prohibiting preventive war in extreme situations, and extrapolate that again to Iran. If, God forbid, the Prime Minister of Israel, whoever he or she happens to be, when Israeli intelligence or US intelligence indicates that Iran is on the verge of turning its civilian nuclear program into a military nuclear program, and if an Israeli prime minister were to attack the Iranian nuclear reactor and in the process kill dozens or even hundreds of people, fortunately only a small number of people were killed, when Israel attacked the Iraqi and Syrian nuclear reactor, but in Iran it might be much greater. The world would condemn Israel. The world would condemn the prime minister as a war criminal because the war wouldn't see, and we would never know. Deaths might be prevented if Iran were prevented from developing a nuclear arsenal. So that's the problem of a sharp distinction between preemptive and preventive war. And I think that the Israeli legal community, including Shurat HaDin, has to be prepared now to write briefs and to make the legal arguments that, God forbid, it becomes essential for survival to attack Iran's nuclear program, that the justification is known in advance. It was Dean Acheson, the Secretary of State under Harry Truman, who said that a nation's survival will never be a matter of law. And no matter who the prime minister of Israel is, no matter how extreme left a prime minister might be, or centrist or right, any prime minister of Israel would never allow Iran to develop nuclear weapons. The policy of containment, which some Americans tried to persuade the United States administration to adopt toward Iran, the policy of containment is impossible with regard to Iran. It must be prevented. Why is containment impossible? Remember what Rafsanjani, the former liberal centrist leader of the Iranians, said some years ago. He said, Iran develops a nuclear weapon and drops it on Tel Aviv, they will kill 3 million Jews, he didn't mention the Arabs who would be killed as well, and destroy Israel, because, to quote him, Israel is a one-bomb state. He then said Israel might retaliate and drop a bomb on Tehran, killing 20, 30 million Iranian Muslims. He said, but the trade-off would be worth it. It would destroy Israel, and Islam would survive, and Iran would survive. When you have a person making those kinds of calculations in a position of leadership, you understand that there might someday be a need for Israel or the United States to engage in preventive war. We all hope it's not necessary. As George Washington said in his inaugural address, the best way to prevent war is to make your enemies understand that you are ready to wage it. And the world has to understand Israel, the United States, are ready to wage preventive war against Iran if it becomes close to developing nuclear weapons. Now, those of us in the room can't help Israel prepare for the military aspects, but we can join together and help Israel prepare for the legal aspects of that. And by the way, creating briefs justifying the use of preventive, proportional, preventive military actions also helps serve as a deterrent, because the message becomes clear to Iran and to the mullahs that Israel is prepared to do what it has to do to stop itself from becoming the victim of the one-bomb state theory that Iran clearly has in its back pocket. So those are the distinctions between preventive war and preemptive war, particularly in the context of the threat of nuclear war. The second distinction that's important grows out of the law of jus in bello, and that is rights and a law during a battle, during a war. And we've seen so much attention paid to that, for example, in the Goldstone report, the despicable Goldstone report, which was drafted by a group of people headed by Richard Goldstone, who was deliberately selected to head the commission because of his connections to Israel and his Jewish background, and wrote a reprehensible report in which he basically said Israel deliberately targeted civilians and that Hamas never used civilians or civilian areas as human shields. He was wrong on both scores. Israel was able, through the use of photographic images, satellite images, and other hard evidence, to demonstrate that he was wrong. But the Goldstone report was all about in bello acts during wartime. And there are two issues that are critically important during a war. One is the principle of distinction, the principle of requiring always a distinction between civilian targets and military targets, something Israel takes very, very seriously. Israel is that the new F-36, whatever it's going to be, has a cockpit for 3 people, a pilot, a navigator, a lawyer, because Israel, with its compliance with the rule of law and advocate general, does nothing without compliance with the rule of law. Israel is one of the only countries in the world, not even the United States, where the advocate general has authority over the military generals to tell them that they cannot do certain military actions. In the United States, the advocate general's advice is that merely advisory. In the United States, it's advisory. In Israel, it's binding. So the principle of distinction is one that Israel has always followed. It's one the Arab states have never followed. During the 1973 war, documents were revealed in which the Syrian Egyptian army instructed to kill civilians and not to destroy civilians. The Syrian army had instructions when they were prepared to come down the Golan Heights and come into civilian areas in the north of Israel to destroy civilians in the cities that it captured. Israel, of course, never does that. And the number of civilian casualties inflicted by Israel in the 1967-73 war were relatively minimal compared to other wars fought under similar circumstances. Now, there's one principle with the concept of distinction widely misunderstood, and that's the principle of proportionality. A lot of people think that the principle of proportionality requires that when Hamas fires rockets at Israel and doesn't kill anybody, Israel can't respond in a way that might kill a lot of Hamas members. That's not the rule of proportionality. If a nation is attacked, it will respond disproportionately to the attack. It may kill thousands and thousands of soldiers, enemy soldiers, in response to the killing of 1 or 2 Israeli soldiers. There are no limits on the number of soldiers that can be killed in response to a military attack. Proportionality simply doesn't operate in the context of military actions against military targets. Proportionality only operates when a target has the potential of including civilians as collateral damage. And then the rule of proportionality says that you have to evaluate the likely number of civilians that would be killed against the importance of the military action that's being taken. I'll give you an example from this week's news. It is reported that President Trump withdrew his attack on Iran because he was told that 150 people would be killed. We don't know whether he was told that they would be civilians or not, but if he was told they would be civilians, he may have made the decision based, at least implicitly, on rules of proportionality. The military target was an important one, but not a central one to the United States' survival, and it would have cost 150 lives. Well, he may have thought that too many. As I mentioned previously, in the attack on the Iraqi nuclear reactor, my recollection is 12 Iraqi soldiers, 1 French civilian were killed. That clearly satisfied the rules of proportionality. In the Syrian attack, I think we had similar results. But if, for example, 1 terrorist were hiding in a hospital filled with children and sick civilians, it would be a violation of the rule of proportionality to attack that hospital to kill 1 terrorist with the risk of killing so many civilians. On the other hand, if you have 10 terrorists in the building, actually occurred some years ago, and you have some civilians in the building, that would be a case on proportionality. Israel, in the end, used a smaller bomb to avoid problems of proportionality and failed to destroy its target. So the rules of proportionality impose costs on the nation employing the military acts, because sometimes it will allow terrorists and others to continue to operate. And of course, terrorism poses significant problems with the rules of distinction. How do you distinguish between a combatant and a non-combatant when terrorists are combatants by night and civilians by day, or combatants wear civilian clothing, or combatants hide among civilians? The rules of distinction were built to respond to Hiroshima and Dresden, when the United States and Great Britain bombed military targets, to be sure, but military targets that knew had lots and lots and lots of civilians, hundreds of thousands, tens of thousands, Both of those actions almost violated the rules of proportionality, but the rules of proportionality don't have quantification or quantitative number. So that's in bello. Now, one of the most complicated areas, which rarely applied in practice, is jus post bellum. What are the rules that apply to a country after a war is over? We know that the victorious country is permitted to militarily occupy areas that it captured. Much more controversial is whether it can bring civilians in and build civilian settlements in captured areas. Of course, that would depend whether they had the right to maintain control over those areas. We know that following the Second World War, there were massive transfer populations. Thousands and thousands of ethnic Germans who had been Czech citizens were expelled from Sudetenland. We know that when Russia captured Königsberg, which had been the capital of a province of Germany, they simply took every single German citizen, expelled them from the city, annexed Königsberg, and Königsberg, though it's not territorially connected to Russia, is now a part of Russia. We haven't seen a single UN condemnation of Russia annexing Königsberg and maintaining it as part of its population, repopulating it with Russian ethnics and Russian citizens, and depopulating it with German citizens. A little bit of murmuring now from Germany and some German citizens about regaining land, but I would not bet widows and orphans' money that that would ever come up, certainly not in the near future. So the issue of occupation, the issue of civilian settlements, the issue of station, all of those are relevant issues. I was privileged to work in a minor, limited capacity with Justice Arthur Goldberg on Security Council Resolution 242, which was enacted in the fall of 1967, following Israel's victory in the Six-Day War. Let's remember that Israel did not start a war preemptively with Jordan. Jordan was out of the war. Israel sent emissaries to Jordan saying, if you don't attack us, we will not take over any territory, including the Kotel, the Western Wall, the access roads to Hebrew University and Hadassah Hospital, the Jewish Quarter. We will leave the status quo intact if you don't attack us. But Jordan, under King Hussein, decided to attack Israeli civilian targets, lobbing rockets at West Jerusalem, and some reaching as far as the outskirts of Tel Aviv. And Israel had no choice at that point but to attack. And in the attack, it captured the entire West Bank. It liberated the Western Wall, the Jewish Quarter, and the access roads to Hebrew University and Hadassah Hospital. And the question is, under the rules of jus post bellum, is Israel entitled to maintain control? And Resolution 242 clearly answered that question in the affirmative. There was a great debate between the Russians and the French on the one hand, and the British and the United States on the other hand, whether to have the resolution talk about the return of territories, all territories, some territories, and of course the resolution in the end just talked about territories. And Justice Goldberg and Lord Carrington both made it clear that that meant that Israel had the right to hold on to some territory. Certainly that included the Western Wall, the Jewish Quarter. And yet the United Nations Security Council, in a despicable resolution last year, engineered in 2016, engineered by outgoing President Barack Obama, a man who I voted for, but who engaged in horrible acts at the end of his tenure, got the United Nations to unanimously, with the abstention of the United States, declare the Western Wall to be illegally occupied territory, declared the Jewish Quarter to be illegally occupied territory, declared the access roads to Hebrew University and Hadassah Hospital to be illegally occupied territory. That is not international law. That is not what UN Resolution 242 contemplated. How much territorial permitted under international law is not an answer that is answered in any discrete way. When people won the war, General Lalonde proposed a plan where Israel would immediately annex territories necessary for its defense. Remember, Abu Ibn talked about the 67 as the Auschwitz line, and plainly, the United Nations Security Council resolution contemplated war that would allow Israel itself from attack and did require it to defend 11-mile wide corridor between a Palestinian entity and the Mediterranean. These issues are still being debated today, and international law doesn't provide any particularly discrete answers. What UN Resolution 242 provided for was negotiation. And some of that negotiation is going on today as we speak in Bahrain, where the Trump administration is offering a plan, particularly the economic aspects of the plan. Many in Israel will disagree with the plan. Many in the Palestinian Authority will disagree with the plan. Many among the Sunni Arabs will have some concerns, but at least it's a plan and it's a beginning. And I would have hoped that the Palestinians would come and at least listen instead of immediately saying no, as Abu Ibn put it many years ago. The Palestinian leadership never misses an opportunity to miss an opportunity. They missed an opportunity for statehood in 1938, in 1948, in 1967, in 1990, in 2000, 2005. And it looks like they're going to miss yet another opportunity and take the opportunity to miss an opportunity. These are not issues of law. These are issues of practicality. Look, the one thing that Israel has to keep in mind, and that is it must maintain its position of overwhelming military superiority over all the surrounding Arab nations. As Elie Wiesel taught us, one of the lessons of the Shoah is always believe the threats of your enemies more than the promises of your friends. Israel must never rely on the United States or any other allies for its security. It should obviously. And I'll end with a biblical source which tells us how to achieve peace. It comes from the Psalms of David. Hashem oz le'amo yitain. God will give the Jewish people oz, strength. Only then will the Jewish people get peace. We have known from the beginning that peace for the Jewish people will only come through disproportionate, overwhelming strength, military strength, economic strength, scientific strength, technological strength, intelligence strength, strength from support from American Jews and American Christians in the United States. So never, ever consider the laws of war as a barrier to becoming the strongest nation, to becoming a nation that's self-sufficient, a nation that can always, always defend itself. I'm often asked whether I'm a pessimist or an optimist, and an Israeli told me a very good definition. He said, in Israel, a pessimist is somebody who's, oi, things are so bad they can't possibly get any worse. An optimist said, yes, they can. But not in that sense. No Jew can ever be a total optimist. We know the history of Jewish life, where good times are often followed by very bad times. Weimar Germany was a very good time, and it was followed by disaster. There are good times now. Israel is strong. Israel is diplomatically strong, militarily strong, scientifically strong, economically strong. But Iran threatens it, Hezbollah threatens it, Hamas threatens it. So without regard to the law, without regard to human rights concerns, Israel must maintain its status as the strongest country in the Middle East. It must have the strongest army, must have the strongest economy. And as I think it was Prime Minister Ben-Gurion, and then he was parroted by Prime Minister Netanyahu very well, when he said, if the Arabs lay down their arms, there would be peace. If the Israelis lay down their arms, there would be no Israel. And so it's so important for Israel to maintain its qualitative military superiority. With the help of Shurat HaDin, Israel will only use its arms in a moral way as it has throughout its history. With the help of Shurat HaDin, Israel will always be able to defend its use of legitimate military actions by the rule of law. So I congratulate Shurat HaDin for the great work it does in helping Israel and defending Israel. And I promise you my continued support. I love working with you together to achieve justice and to maintain Israel's superiority militarily and to maintain the rule of law. So thank you, and may you go from strength to strength.
Thank you, Professor Dershowitz. This is beautiful to hear such compliments and wishes for collaborations from someone like you. We are flattered, we are privileged, we're honored. Thank you very much.
Thank you.
So I would like to introduce you our next keynote speaker, former Minister of Education, Naftali Bennett, who's a good friend of Israel and Shurat HaDin. And I think it probably does not need a lot of introduction in this room. Naftali Bennett served in the Knesset as chairman of the